Hello, everyone, and welcome to TEP Talks Professional Series, a groundbreaking new podcast dedicated to showcasing the diverse career journey and professional accomplishments of TEP alumni, brought to you by the TEP Foundation. I am your host, Stan Silverman, URI Class of 79, Tau Omega 402. It's my privilege to speak to TEP brothers across a wide spectrum of industries, gaining insights into their fields, advice for breaking in, and a realistic look at the day-to-day work behind some of the most impactful careers in the modern economy. Personally, I found so many of the brothers with whom I spoke to have such interesting stories. I'm sure that in addition to the educational benefit that you will gain from watching and listening to these professionals, the stories that they tell are just plain fascinating. So pick one, anyone, or pick them all. I'm certain that it'll be worth your while. Thank you and happy watching. Hello, everyone. Today, I have the privilege of speaking with Larry Kunin. Larry is a practicing attorney at law who now does arbitration and mediation. So, without further ado, here we go. Very nice to meet you, brother.
Nice to meet you too.
Thank you. So, you are quite an accomplished and educated man.
I've been around a few universities.
I checked out your biography, and you were working and going to school at the same time, and gosh, you were busy.
I was. I was.
So
Um,
I'm sorry, go ahead.
I said, and now taking advantage, slow down a little bit, but still working.
Okay. So you started out in technology as a programmer,
That is correct.
and then you got your MBA, and then you went to law school, and then you practiced as a lawyer, and then you went to school to become a mediator arbitrator. How did you?
Yes, so sort of to clarify that, I didn't go to school to become an arbitrator mediator. I started doing ADR work. It's called alternate dispute resolution work over the last several years of my litigation career. And decided that's where I wanted to take it. So I took certification classes, but I wouldn't call it going to school.
Okay. So the certification courses were online or weekends or evenings, or how does that work?
Um, uh, well, ever since COVID, they're technically online, but they're not like what a lot of people think is an online course. We actually had sessions that were live with the trainers, live with other people who were involved in the class, doing the exercises, doing the play acting, because there is a skill to being a mediator and an arbitrator. And for those people listening to this, the difference between mediation and arbitration, mediation is a settlement process where you have a neutral who works with the parties, puts them in different rooms, goes back and forth, talks to them about their case, talks to them about the challenges, and tries to get a settlement without making a decision. The parties are in 100% control of their resolution if they reach one. And mediation is wildly successful. A very high percentage of cases ultimately settle at mediation. Arbitration is a substitution for court. So as an arbitrator, I'm like a judge. I make the decision. I hear the emotions. I hear the arguments, etc. So that's the difference between arbitration and mediation. And if you get an arbitration award, it's binding and it gets recorded in court and becomes a judgment of the court. So
So
that's
obviously, both
different.
sides have to agree to arbitration.
Yes. So arbitration is a creature of contract. So when two parties get together for a contract, and it can be anything from a consumer contract, the installation of, air conditioned systems in some of my properties. It could be business to business, development of software, purchase of hardware, sale of intellectual property. In that contract, the parties may have a clause that says, should any disputes arise between the parties related to the contract, that it will be decided by arbitration rather than court. And it may or may not also state what arbitration tribunal you go with. I'm with an arbitration tribunal, a nationwide tribunal called JAMS, which is Judicial Arbitration and Mediation Service. About half the JAMS arbitrators are retired judges, and about half are practitioners who practice for 25 to 30 years, like myself.
How much of your practice is arbitration and mediation, and how much is other law things?
Currently, I'm 100% arbitration and mediation. I
Okay.
retired from my law firm at the end of 2024. So that was the end of my litigation career, with the exception of one case I retained that not worth going into. And then joined JAMS. So I am now doing mediation and arbitration work. And when I say full-time, meaning I'm not doing any other work, but I'm not doing it 40 hours a week. I'm doing it probably 10 to 20 hours a week.
Okay.
And so basically I moved from one to the other, but there was an overlap. I started mediating about 5, 6 years before I retired.
Okay. How much of the mediation, or I guess more mediation, how much of it is somebody's feelings got hurt, and how much of it is just facts?
That's a great question. Um, when you talk about things like, employment contracts or employment disputes, consumer disputes, there tends to be a lot of emotion on one side, not so much on the business side. When you're talking about business to business disputes, you generally don't deal with emotion, but that's not exclusive. Sometimes you do get a chief executive officer, chief financial officer, somebody involved in the project, like a software development project, who takes it personally. And that comes out in the ADR process. And part of that process is letting that person talk and air their grievances. And
Okay.
hopefully that leads to settlement. So it's a mixture, but generally the smaller a party is, whether it's an individual or a small company, the more likely you've got emotion. The larger the company is, up to publicly held corporations, you don't get a lot of emotion. It's pure business. It's dollars.
Okay. I saw that you left one law practice and then joined another, and you were a partner after. Okay, I watch a lot of television, and I'm watching Suits, and I'm watching. You became a partner after only practicing for like 5 or 6 years.
Yeah, it was actually year 8 to be technical, but I can explain how that occurred. Working backwards, the firm I worked for 25 years in Atlanta has an 8-year partner track. But I worked for a firm for 5 years before that in Miami, and that's where I started my practice. A practice, I wouldn't call this a tip, but kind of how my career worked out. I joined a firm in Miami that was about a 20 to 25 person law firm, kind of fluctuated over the years. They threw me into the courtroom immediately. I did my first cross examination 6 months out of law school. I was arguing hearings. I was appearing in court and examining witnesses. It was a tremendous training ground, tremendous training ground. When, for family reasons, we decided to relocate to Atlanta, it wasn't just family reasons. It was I was doing a lot of technology work, and that didn't come by every day in Miami, but it came by a lot in Atlanta. So I joined a tech-heavy law firm, a very large law firm of over 200 lawyers. Um, they recognized fairly quick that I already had the skills that were way ahead of the associates that they had, that they would bring in and do legal research for 2 years and that type of thing. So they gave me 100% credit for my 5 years of service in Miami. Plus, I actually graduated early in December of 2020. I'm sorry, 1994. Um, Technically, that made me a 94 grad, even though it was late 94. So you take 94, you had 8 years, You get to 2002. I was eligible in 2002, 2 years after I joined the firm in Atlanta, and made partner on my first ballot.
There must have been law school graduates who would not have been successful cross-examining people 6 months out of law school.
I would imagine not. Usually the normal track is you do a lot of drafting. When you come out of law school, you do a lot of research. You start to attend depositions, maybe attend trial, maybe handle some like really small things and slowly work your way up over the years. My first cross-examination occurred with no notice. I was sitting with a partner. Um, a witness was being examined, and when the witness was done being examined, the question came, do we have any cross-examination? And I looked at the partner and he's staring at me. And he said, well, and I said, well, what? And he said, aren't you going to cross-examine the witness? I had no time to get nervous. He knew I knew what to ask him. He knew I knew what the exhibits were because I'm the one who prepared all of it. So being that I had no time to get nervous, I just jumped right into it. Bang. And I actually got the witness to recant his testimony. But that's
Wow.
the best part of all. But that doesn't happen every day, and it doesn't happen to everybody. But yeah, starting with a smaller firm, definitely it's a trade-off. You don't make as much money, but you get a lot of training. Go to a big firm, you get the big money right out of the box, but you're not going to get the same speed of training.
So since you opened that that avenue, Mr. Witness, so what does this small firm pay versus what does the large firm pay right out of law school?
I couldn't tell you today, to be honest, because I just don't know. I know that the big firms, and it depends on the city you're in. I know in Atlanta, it's like something in the high hundred thousands, right out of law school. When I came out of law school, I took a $45,000 job, whereas the big firms were paying 75,000.
Okay.
Okay, that's a big jump, 30,000. But I really liked the firm that I interviewed with. That was the $45,000 firm. And like I said, the training ground was unbelievable. And the partners in that firm have remained mentors to me to this day.
Oh,
I,
that's great.
I'm very active in the Florida bar, even though I live in Atlanta, and I see a lot of them at the Florida bar annual convention, which I go to every year. I've gone to it every year for as long as I can remember. And I serve on committees in the Florida bar as well. So just because I live out of state doesn't mean I can't participate.
Oh, that's great. Did you clerk as you were going to law school?
I did not. Um, you noted earlier in the interview how I worked for 7 years, doing computer programming. I was married. I'm now living in Gainesville, Florida. As a married person, entered law school at 29, was 30 before the end of my first year. It was time to get in and get out. I didn't have time to do the full experience, now go on to a clerkship, which doesn't really pay a lot. At some point, I had to start making money
Mm-hmm.
and start a family. Um, but having said that, clerking is a wonderful experience. I know a lot of people who've done it, and they are definitely more prepared when they come into a law firm than somebody who's just coming in with no experience. Um, that doesn't include summer associates. During law school, you could go to firms and work for them in the summer, and that gives you a head start on learning how a law firm works and how research works and things like that. Because law school is really good about teaching you theory and substantive law and stuff like that. You really learn how to practice law at a firm or as a clerk where you're actually doing the work, the real work.
You were working as programming. What made you decide that you wanted to become a lawyer?
So a few things. One, and I'm laughing because it's a little humorous. I call it the screen test. You know how when actors go and try out for movies and TV shows, they do a screen test. My screen test was, if I sit in this cubicle for one more day, I'm going to put my head through the screen. Programming, it can be very fruitful for people. But you sit in a cubicle and you're basically on a phone, not on a phone, you're on the computer all day and you're typing code, and there isn't a lot of socializing. And it just was kind of narrowing to me. Uh, Plus, I had some friends who went to law school right out, traditional lawyers, right out of undergrad, went to law school, and they enjoyed their lives and they were doing pretty well. And I thought maybe I should do it. So on a whim, I signed up for the LSAT, the law school aptitude test. Signed up for that with, like, I don't know, 3 weeks notice, paid the late fee because I hadn't registered early enough. And I went in and I scored in like the 96th percentile. And I went, I think this is what I need to do. And I'm at a stage in my life where if I don't do it now, it's just going to get harder to do it later. So my wife and I decided, we don't have kids yet. Let's go do it. And I got to tell you, it was a great experience being in law school at that age. I was not the oldest by far. I mean, there were a lot of people in my class who were older than I was. Um, but it was almost like a second youth. I mean, kind of hard to say you're out of your youth when you're 29 years old, but you're not 21. Um, and it was a great experience. And still in contact with my law school classmates. But that's the story. Was, I just hit a point in a career where I said, I don't think I'm going to progress further in this career. It's not in me.
I don't mean to keep harping on numbers, but your last year as a computer programmer, your first year as an attorney, how does that jive as far as pay goes?
Wow, I can't even remember what my last salary was before I went to law school. It wasn't as high as 47. I want to say it was somewhere in the 30s. So it
Okay.
wasn't a significant jump. The difference is I was working for a company. I was working for the Miami Herald. So my pay was basically salary, annual adjustments for cost of living, and a raise, and it slowly moves up. A law salary moves up significantly faster. Because as you progress through being an associate, not only are you getting raises, not only is the market adjusting, but then when you make partner, there's a pretty big jump. And to be clear, there's a difference between being a partner and being a partner. Um, that all comes down to your business generation, your numbers, and things like that. So not all partners are created equal, just so people understand that. A first-year partner is not going to make near as much as a 30-year partner. And even a 10-year partner could make more than a 30-year partner if their numbers are better. But that's the big difference to me, was I didn't look at it as how much more money am I going to make as a lawyer in the first year. I looked at it as more of longevity and interest in the career I was going into.
When you said business generation, do you mean bringing in clients?
Correct.
Okay.
Bringing in clients, managing clients, growing clients, um, saving clients. In other words, a client's about to leave and you save the client, which preserves revenue. That's what I mean by business generation.
Okay.
Law firms are not much different than every other business on earth. You make money by increasing your sales. Sell more cars, make more money. Sell more furniture, make more money. Get more clients, make more money.
Do you have to pay to become a partner? They did that in Suits. I didn't know if that was normal.
It depends on the law firm. Some have what they call a capital charge, where you buy into the partnership, and then you have that share. My firm did not have that. You just basically were admitted into the partnership, and then they assign on an annual basis how much of the firm you own, again, based on your ownership percentage. So my firm didn't have it, but other firms do, and I couldn't identify for you which ones do and don't.
Okay. Okay, so I read your biography. Took me hours, but
It couldn't be that long.
um, so you were a tech person, but some of the cases that you must have to make decisions on, either because they're new technology like AI that you didn't do when you were a programmer, or because of intricacies of particular industries. How do you research and bone up so that you know what you're talking about?
Um, it's actually easier than you think. Um, my tech knowledge from being a programmer and educated in computer systems um, is applicable today. All right, the programming is different, no doubt about it. I couldn't program the apps you have on your iPhone, or that kind of thing. But the aptitude of what you're doing has always been the same. You draft code in modules, modules talk to other modules. The level of programming and the speed of the computers is improved. That aptitude helps me understand a dispute. And so this is why I got heavily into technology related disputes, which was more than half my practice. Software implementation, software development, trade secrets in the development of technology, etc. Um, AI, it is a different animal, but at the end of the day, AI is still computing. It's absolutely computing. And so a lawyer always has to rely on their witnesses, their clients, their expert witnesses in order to educate them. It's the aptitude that helps understand. So let me give you an example. The My first really big tech case was in Miami, or well, I was with my firm in Miami, and it was Microsoft we represented. We had to fly to Redmond, Washington, go into their conference room. I went with a senior partner, and we sat in front of a whiteboard, first whiteboard I'd seen. This is a while ago. And they sat there with the circles and arrows and the boxes and the flow charts and the API. API means application program interface. That's how modules talk to each other. It's like how the spell checker talks to the word processor. Um, and they were drawing all this stuff. And I'm taking my notes and everything's going great. And then I go to dinner that night, and the partner said, I have one question that is going to determine how involved you are in this case. I said, okay, shoot. He said, what the hell were they talking about? I said, you didn't understand that? He said, all I saw were circles and arrows and boxes. And I said, I understood it all. Now, it was a completely different program from the stuff that I had programmed, but I understood how these things work. And that's when I realized I had an aptitude to do these kind of cases. Um, AI, just switching to that, it's new. It's new to the law. And there are different applications for it. Now, AI is being used in social media to publish stuff, and there's been talk about whether AI could create defamatory stuff. Um, Anyone who's been on social media has seen a lot of videos and stuff like that that are just flat out fake. But there
Mhm.
are other uses, helping you draft a letter, uh, helping you draft a brief in the law. But that's where it starts to get dangerous. AI has been known to create fake cases. They call them hallucination cases, where a lawyer will say, here are the facts, draft me a brief that concludes the following, and it drafts out a brief for you, citing cases, and then they turn them into the court. And it turns out those cases are fake. All it takes is the lawyer to actually check every case to make sure they're real. And there are plenty of resources that lawyers know about: LexisNexis, Westlaw, The different bar associations have their own legal research databases. Actually check them. It's such an easy thing to do. Well, lawyers have been sanctioned because they didn't learn how to use AI. So this is use of AI. Lawsuits about AI are kind of slow coming. I did have one that had to do with trade secrets. In other words, somebody developed an AI platform, and then they went to take it to somebody else. And so the claim was, you're stealing our trade secrets and our copyrights. That's one of the few that I've seen that's an actual litigation over AI itself. So you could have licensing disputes, and you could have some certain creativity disputes. I wonder what would happen, and I don't know, but I'm curious about it. What would happen if AI creates a song, and that song happens to be almost identical to a Beatles song? Do the Beatles have a right against who? Not, I guess it's two of the Beatles are still alive, right? Three alive.
Ringo
Well, Ringo and Paul are still
and
alive.
Paul.
Yeah. And so, someone has the rights. Well, who would they sue? Because AI created it. This is the stuff that's being sorted out right now. And by the way, talking about technology related litigation, that's what got me into doing mediation and arbitration work. I and other practitioners have had a frustration over the years of having a problem finding mediators and arbitrators who understand technology. When it comes to mediators, you generally find a mediator by agreement with the other party. Arbitration, I mentioned that you have an arbitration clause in your contract, and it may say you have to go to some tribunal. So you go to the tribunal. They say, what do you want in an arbitrator? I want somebody who understands software development. And then they send you the same list of 10 75-year-old retired lawyers or judges who don't understand the first thing about technology, and you're stuck. And one day I got a call from a colleague in the Florida bar, and he said, we have a trade secret technology dispute, and we can't find somebody who understands it, but you do. You want to do this? And I went, sure, sounds like fun. I did it. We settled the case, and I said, this is what I need to do. That's how I got into where I am today, as far as being an ADR neutral. And I do more than technology. I'll do anything business related. I've got some employment disputes. I've got some consumer disputes. I will not do a family law case. That's like out of my realm. Environmental case is probably out of my realm. Probably would turn that down too. But basically anything that involves a business, that's what I'm doing.
So when the case is over, do most of the sides get 50-70% of what it is they wanted?
That's a loaded question.
Sorry.
Yeah, no, that's okay, because every case is different. There's a famous phrase in the legal field when people ask tough questions. The answer is always, it depends.
Okay.
Get mediation is a settlement process. The parties are going to meet somewhere in the middle if they settle. Somebody's got a demand here, someone's got a demand here. You're gonna meet somewhere in the middle. Arbitration. I've been involved in arbitrations that find completely for the claimant. I've been involved in arbitrations that are completely for the respondent, and I've been involved in arbitrations that are anywhere in between. There's some thought out there that arbitrators like to split the baby, the old Solomon story. And that's really not true, unless it truly is a gray area through the whole suit that the arbitrator is just looking for a fair result. But I've seen claims where somebody says, I'm owed $200,000 on the following 10 invoices, and the arbitrator will look look at the invoices, listen to the testimony, and conclude, 8 of these are valid, 2 of these are not. And so that's where you get the somewhere in the middle. I had an arbitration a couple of years ago. I was representing a litigant. I was not the arbitrator, where somebody was looking for $500,000, and they had one invoice that was not issued. And the arbitrator said no to the $500,000, but I'll give you the $15,000 unissued invoice. So kind of threw a bone, right? They threw something at them, but essentially they lost the case.
How much does it cost to have an arbitration case?
Okay, my famous phrase, it depends.
It depends.
It depends. So I had 2 arbitration calls today. One of them is why I was late meeting up with you. One of them, the value is around $20,000. Well, the last thing anybody wants is for the arbitrator who's charging by the hour and the lawyers to be charging by the hour to charge $50,000 on a $20,000 case. It's a straightforward case. It's a short contract. One party says it wasn't performed. The other party says we performed. It's going to be one witness aside. That arbitration probably will cost them about $7,500. Okay.
That's the arbitrator fee. That doesn't include the 2 attorneys.
That's correct. That's correct. And then the arbitrator, sometimes you can award attorney's fees, sometimes you can't. Arbitration and just about every court in the country follows what we call the American rule. And a lot of litigants don't understand this. They go to their attorney and go, and I want you to get my attorney's fees. Well, it's not that easy. In order to get attorney's fees in litigation, you have to either be suing on a statute that allows for it, and most cases in arbitration are not statutory claims. There are a few, but most are not statutory claims. Intellectual property ones are. I should clarify that, because intellectual property ones, that there's a Trademark Act, a Copyright Act, there's the Defense of Trade Secrets Act, there's the Patent Act. Those are statutory, and they do allow for attorney's fees. But the other way to get attorney's fees is if your contract that's at the base of the dispute has an attorney's fees clause, then you can award it. But if you're not suing under a statute that allows it, and your contract doesn't allow for it, you don't get attorney's fees. You don't get attorney's fees. But back to your question, yeah, arbitrator fees to handle, even a $20,000 arbitration probably is about $7,500. Now, having said that, JAMS, who I'm with, has what's called consumer minimum standards rules, which is where if a consumer sues a big company over a consumer contract, the big company is required to pay the vast majority of the fees, not the consumer. Unless, again, there's a clause that says that can be shifted, but at least going into it, they pay a few $100s, and the other company, the respondent, has to pay the bigger portion of the fee. And this is actually in most good company contracts, because they've learned that these are the rules, so they put them in the contract so that they don't run into somebody running to court and them getting smacked down by a judge. But yeah, that's how much it could cost, because my rate, for example, as it is right now today, $650. So 10 hours of my time is $6,500. Well, a day of a hearing is 8 hours. That's without all the preliminary work and the writing the order and all of that. So even if I have an arbitration hearing that's 4 hours long, I'm still probably going to get close to that number. So then the other end of the spectrum you talked about, I've had multi-million-dollar arbitrations that involve not only a significant contract, but a lot of discovery, meaning a lot of emails, thousands of emails, thousands of project documents, issues, the documents, so you may have 10,000, 15,000 documents in production, and the parties have to review that, and then you get to a hearing, and each party has a binder of 100 documents as exhibits. and you've got 4 witnesses, maybe, 3, 4 witnesses, and a hearing that's going to last 4 or 5 days. You're talking about an arbitration that just for the arbitrator alone can get to, $70,000, $80,000, not to mention what the parties are paying.
Do you have a staff, or do you have to read all these documents yourself?
Oh no, I have to do it myself.
Wow.
Oh no, let me clarify. I don't have to read the $15,000 documents. I don't have to. That's up to the parties. That's their discovery. It just shows the largeness of the case. I only have to read what the parties submit to me, either as part of a motion or as part of the hearing. So what I read is the claim, which usually is like a complaint somebody would file in court. The response may be a counterclaim with that, and the response to that counterclaim. And then maybe during the course of the case schedule, the parties have a dispute over, the other side's not producing this category of documents I asked for. I want you to move, I want you to compel them to do so. And then I've got to do that. So I read all of that stuff. So in other words, I'm no different than a judge in court who has to read what the parties are actually submitting. Now, a judge does have clerks. You asked that question before about law clerks. Judge does have law clerks help him sift through that. And I do have, if I feel the need, I do have access to people within JAMS who can help me sort through these things. I just haven't needed it yet, but the day may come, but it's there. I also have research help. So, parties submit stuff to me and I want to research something. I have access to that too. And I have people who can help me in jams. So, but as the decision maker, I've got to be the one to review this stuff. If I don't review this stuff, my award could get attacked. And by the way, arbitration awards are very hard to overturn. It's not like in court where there's an error of law, a document got admitted it shouldn't, an objection was overruled, it should have been granted, or vice versa. And then you go on appeal, and then you can go to the Supreme Court of your state, or if you're in federal court, you could try to get to the Supreme Court of the United States. Good luck with that. Very few cases do. Arbitration has very limited grounds. You can appeal arbitrator misconduct. During the course of the arbitration, I go and have drinks with the counsel from one of the parties. That's bad. Impartiality problems. Turns out I did not disclose that my cousin was actually married to one of the parties. Failure to let a party put on their case. So if I go, all right, we're going to have a hearing, but I'm not going to allow you to put on witnesses, and I'm not going to give you a schedule. You're just going to come in and wing it. I'm not allowing them to put on their case. So these are the kind of grounds. Fraud's another one. Turns out somebody paid me off.
Okay.
That would be bad. Sounds like a bribe. That's exactly what it is. But there's other kinds of fraud too. So it has to be something like that. But the best way I could give good service to both parties is for me to actually review everything that they submit to me and read all of the briefing they submit to me and give a reasoned decision every time.
If somebody brings up a ridiculous consumer case, they threw their toaster in a bathtub and it killed somebody. Okay, that was a stupid. All right, they had some ridiculous. How does if the company is paying the arbitration fee, how does that ridiculous case get stopped before those dollars are spent?
Because most of those cases do have an attorney's fee shifting provision.
I'm sorry?
Most of those cases do have a provision that allows for shifting of attorney's fees. And so that's the hammer over the person. But if you don't have one of those clauses, and I can tell you that I have about 6 consumer cases now, every single one of them allows for shifting of attorney's fees. But if I have one that does not allow shifting, a party can still bring, depends on the state, but a party can still bring a claim under a statute for bringing a bad faith claim. There is what's called in federal court Rule 11. In Florida, it's one. I'm blanking on the number now. 1.1. I don't want to say the number because I'm going to get it wrong. But it basically says that when you sign a pleading, whether you're an attorney or a party, you sign a pleading, you have a good faith basis behind it. And if you do not have a good faith basis behind it, then the court can shift attorney's fees. Well, that's a statute. Remember, I said you have to have a statute. It's a very, very high standard to prove that. I think I've seen Rule 11 granted once in my career, and I've never seen the Florida version granted. But if there's discovery abuse, the arbitrator can award fees for the motion to address the discovery abuse. A party that goes in bad faith ultimately will get theirs in the end. But like I said, it's a pretty high standard.
Okay. I was in a mall, and the mall lease had arbitration, and so the mall's office is in Syracuse. I'm in Poughkeepsie, New York. So the lease said that disputes had to go to arbitration in Syracuse. We never did, but is that something? Is that a home team kind of a thing where I was going to lose if I brought them to arbitration in Syracuse, their home turf?
Two answers to that question. One, I've never bought into the home team thing, with exception. There definitely are some exceptions out there. Like I've never believed that I have to be the plaintiff as opposed to the defendant who files a counterclaim. I don't always buy into the home teaming, because if you've got a right arbitrator or you've got the right judge, then you're going to get a just result. Where the exceptions come in, and they're pretty rare. You get it's not an arbitration, but you get it in court where a judge now has a lawyer in front of him who's donated $10,000 to his campaign over the last 10 years. That's not disqualifying. In arbitration, it is. In arbitration, if I said, hey, I ran for city council, and I need to let you know that the lawyer for the petitioner donated to my campaign, that's disclosable. And then it's up to the parties to decide if they want to disqualify me or not. Here's the other answer to the question. Especially in consumer arbitrations, I mentioned these consumer minimum standards that JAMS has. That also addresses venue. And the venue must be convenient to the consumer. So if you've got a company in California that is selling septic tanks, and they sell to somebody in Florida, and something goes wrong, and the arbitration clause says you're going to go to JAMS in San Francisco. You file with JAMS. JAMS minimum standards, consumer minimum standards, is going to say, oh no, you're gonna bring this where the petitioner is. You're going to have to go to Florida. Otherwise, we're not going to administer this. And then you end up with a fight. I've yet to see a problem with application of these minimum standards. Now, again, I'm speaking on behalf of the entity I'm with, JAMS. I don't know if other entities have rules similar to this, but I suspect that they do. Because, one of the things the law looks out for is not punishing people because you're a single person going up against a public corporation located in another state. Everybody should have access to justice, and you just can't contract yourself out of that.
So you're a member of JAMS. There must be other arbitration and mediation societies.
Absolutely. The most famous probably is the AAA, the American Arbitration Association. There's an entity in Atlanta called Miles Mediation that's starting to grow outside of Georgia. INTA, which is the International Trademark Association. They've got their own tribunal for especially international arbitrations. Um, there are numerous others that are out there. I would say the most well-known tribunals in the United States for domestic stuff is the AAA and JAMS. Um, they're both located across the country. Now how you work with them is a little different. Um, you can, like, for example, with the AAA, you could be a AAA arbitrator and still can keep your private practice. With JAMS, I'm not allowed to have a private practice. So I only JAMS. And if I get hired, by the way, I am working on a AAA arbitration right now. I'm not a AAA arbitrator, but the parties to the AAA arbitration agreed, their contract said they had to go to AAA, but the parties agreed to hire me. So basically, JAMS is serving as the arbitrator. And so I do my billing through JAMS, and JAMS submits them to the AAA. And the case file is maintained on the AAA site. So even though I'm not technically with the AAA, I am handling a AAA arbitration.
Of course, the most famous arbitrator of all time is Peter Seitz, who ruled on the catfish hunter contract.
Oh,
Have
yeah.
you have you seen that?
I couldn't cite it to you in detail, but I've heard about that arbitration, and I know the catfish hunter issue.
Charlie Finley apparently didn't send him out his contract or a bonus check when he was supposed to, and Peter Seitz said, "You're a free agent," and then he came to the Yankees.
Yeah, well, there you go.
And
And talk about arbitration. Baseball arbitration is a phrase that you hear people use because it arose out of baseball negotiation and the collective bargaining agreement with the MLBPA. Baseball arbitration is where the arbitrator has to find one way or the other. There is no middle ground. One party says A, the other one says B, and the arbitrator decides which one. That's kind of harsh, but that is what the collective bargaining agreement provides for. So that's pretty unique. I don't encounter that kind of thing. Now, if the parties told me they wanted that, it's the parties' dispute. If they said, listen, Mr. Kunin, we would like you to give it a decision one way or the other and nothing in the middle. And if the parties are in agreement to that, then I'm just going to comply with the parties' agreement and I'm going to decide one way or the other. I haven't encountered that yet, and I don't anticipate encountering it, but that's how I would handle it.
okay. So how long have you been doing just arbitration?
I onboarded with JAMS in June of last year.
Okay. In the bio, it says certain factual and legal issues, should the matter not be resolved, what are you going to do about it? Okay, good.
All right, it's talking about my skill, which is, and I'll read what the actual quote is. It says, as a neutral, Mr. Kunin strives not only to understand the facts of a dispute, but also to draw on direct experience to identify relevant issues and have the parties explain how they would respond to certain factual and legal issues should their matter not be resolved. All right, what that's referring to is that when it comes to mediation, a mediator is not allowed to tell the parties, I agree with you, I disagree with you, you're right, you're wrong, you're going to win this case, you're going to lose this case. But because I understand what issues arise in these disputes, a software development dispute as an example, I could tell you what most of the arguments are in a software development dispute before you even tell me what your dispute is. Because I've done so many of these cases, there's a lot of common issues. So this puts me in a position where I can then say, how are you going to respond to the fact that you didn't have a change order for this request that you have for the software to function a different way? How are you going to respond to the fact that there's an issue on the issues list that's been there for 10 weeks without any movement whatsoever. That's what I'm talking about there is a mediator cannot say if you're right or wrong, but a mediator can challenge you on your positions.
Okay.
And the object is to make the parties start to feel a little uncomfortable because parties fall in love with their own case very quickly. Their own lawyers fall in love with their own case very quickly. And they are very quick to discount what the other side says. But parties have a hard time putting themselves in the neutral position, whether it's an arbitrator or a judge or a jury. They have a hard time doing that. And so you get to challenge them in mediation. How are you going to explain this to the jury? I have a case that current where somebody claims that they didn't do something because of an email where the other side said, don't worry, we're going to monitor this for you. Okay. And it had to do with a certain level of fraud detection. We're going to do this for you. Then they turn around and they go, we found that you did X, Y, and Z wrong, so we're terminating your contract. And they went, wait a minute. You told me you were going to keep an eye out for that. So why are you blaming me when you said that? Well, we're going to mediation. As long as one party, the other party, shows the email and gives it to me during the mediation or beforehand, because there is some document exchange beforehand, I go into the room and I put it down and I go, here it is. It's a 1-sentence email. We will do the fraud detection for you. How are you going to address that in front of the jury? So that's what I meant by that sentence.
Okay. Thank you. If a young person decided that they wanted to become a mediator, arbitrator, how would they need to go to law school first?
Shorter answer is no.
Okay.
You do not need to be a lawyer in order to be a mediator or an arbitrator. In fact, in JAMS, we have several neutrals who are not lawyers or mediators. Now, they may have some specialty, real estate, construction, something like that. But the vast majority of arbitrators and mediators did go to law school. And there's a benefit to being it's going to law school, which is you understand what the law is. And you understand how statutes work and all of that. Now, I'm not saying that somebody who didn't go to law school cannot be overly competent in dealing with an arbitration or a negotiation. A lot of negotiators are not lawyers. Every day there's negotiations going on. They're not lawyers. But when you start getting into things like commercial contracts and fair debt collection practices and the Copyright Act, and you start getting into that kind of stuff, it really helps not only to have gone to law school, but to also be experienced. I am not aware of anyone who graduated law school and became a neutral immediately. Just not aware of it. But again, I just mentioned that you don't even have to go to law school. Well, that means somebody went into it without even going to law school. Well, it's because I think they're two different categories. One is, the people who don't go to law school, they're not coming out of college and doing it either. They're getting experience somewhere in the business world. So experience is gained somewhere. People coming out of law school, they got to work for a while. I know very few mediators and arbitrators who are under 40 years old. In fact, I'm not even sure there's one guy I know and highly respect down in Palm Beach, who I think he started in his 30s and he might be 40 now. I'm not even sure. But he worked for a really, really good law firm. That just so happens to be the same law firm I worked for in Miami. That gave me all that experience. We didn't work together. We underlapped by well more than a decade. But same training ground. He learned an awful lot and started doing it on the side and got very popular. And he's actually a jams arbitrator now, along with me. He joined after me. But he started young. Other than him, the vast majority are people towards the end of their career, or retired from the judicial bench, which again would be more often than not at the end of their career.
You're noted as a neutral by the state of Georgia.
Yes.
How did you get that certification?
Okay, so if you want to do court annex mediations in Georgia, meaning assigned by the court, most courts will require the parties mediate at some point. Well, in Georgia, if the court orders mediation as part of a lawsuit, you have to be a member of the Georgia Office of Dispute Resolution, or GODR. And you have to register for that every single year. In order to register for the GODR, you have to have taken a certification class.
Okay.
So that's what I did. I took a certification class when I realized this is the way I was going to go. And as soon as that certification class was over, I then registered with the GODR, and that's my registration, that being certified by the state of Georgia.
What if one of the parties in a mediation won't move off the dime and just says, I want $100,000 and that's what I want, and I'm not discussing this?
First of all, that's their right. It's actually a right that is explained at the beginning of mediation, that a party is allowed to walk out of the mediation anytime they want. Even if a court orders you to mediation, you comply with that by showing up. But the court can't force you to do it. And they say you got to negotiate good faith, but what's that? If I believe in my case, I believe in my case. So that's their right. It's the mediator's job to say, well, before you take that stance, before you walk out, the mediator's got to do the mediator's job by pointing out, have you considered this and considered that, considered, the costs of the litigation, the risk. There is, I think it was David Boyce, the famous litigator, back in the Hanging Chad days. I think it was him who said, you have a 20% chance of losing your case just because it exists. Meaning you could have every fact in your favor, but juries do funky things. And you got a 20% chance you're going to lose just for that. And then you're going to spend money in your attorneys. And then you're going to have a distraction. Meaning you're going to have to sit for depositions, and you're going to have your staff start pulling up thousands of emails. And you go through all that stuff. And then if the parties have properly educated the mediator could even get into the merits. Like I said, the email. I understand your position, but how do you think that email is going to play in front of a jury? And try to get them off. And if they say, I hear you, I've heard it all, I'm sorry, I'm not changing my mind, that is it. Well, then the mediator at that point would tell the other party, that's their final demand. They're not moving off of it. Do you want to accept it, or do you want to reject it? In which case I will call an impasse. And that's we didn't talk about this. There's 3 ways a mediation can end. You can end with a settlement, can end with an impasse, which some courts require the mediator to report back to the court that there's been an impasse. And the other is continuance. And that could happen where during the mediation, the parties just aren't close enough yet. But there's some discussion about some facts, and maybe somebody wants to take another deposition, or maybe they want to exchange some additional documents. And then you'll have another session later in time. And sometimes it's just individual phone calls. Another difference between arbitration and mediation is the mediator can talk ex parte, meaning one party only, with each party. I could talk to the plaintiff, I could talk to the defendant, I could play them off of each other. I could do whatever it takes to get a settlement without crossing the boundaries of making a decision on the case. Arbitrators cannot talk ex parte with the parties once they've been impaneled. They can be interviewed before, like somebody wants to call me up and say, hey, I got a case looking for an arbitrator. Is this the kind of thing you would do? And if so, I'll mention it to my opposing counsel. That's fine. Once the arbitrator's impaneled, the parties can no longer talk independently with the arbitrator and vice versa. Everything has to be joint. So that's the difference. But that's where, going back to the continuance of a mediation, the mediator may follow up with one party or the other after the mediation, maybe they've on a preset schedule, maybe just ad hoc, and see can we move this thing to conclusion. I'll give you an example of a mediation I had 2 weeks ago. Software development dispute. A lot of emotion on one side. It was a business to business dispute, but there was a lot of emotion. And the parties were like $200,000 apart. And I just flat out said, in so many words, you're crazy not to settle this suit. Because has your attorney given you a budget for this case? Yes. And how much was it? It was around $300,000. All right, go to the other side. Have you given a budget to what this is going to cost? Yeah, we estimate around $350,000. I'm like, you both are spending more on your attorneys to walk away from this dispute, which guess who's going to be the winner? The winner's going to be your attorneys. Your attorneys win. And you know, whoever spends $300,000 to save 200 is nuts. And you know, and I use more professional language, but that's the point. And that was somebody who he told me, he said, I'm at the end of the rope. This is my last and final. And I said, now when you say last and final, you better mean last and final, because if they counter and then you counter, then they know when you say last and final, you don't mean it. He says, well, tell them last and final, but you think you can sell lots. I said, that's not last and final. It's just not last and final. So, you know, there's a lot of tools that mediators have in their bag of tricks. You know, now a lot of these the lawyers know, because most lawyers have been through numerous mediations, but the parties have not been through this process. You know, sometimes you have a party who's been through 5 mediations because of the nature of their business, they get sued. And most people, it's the first time they've ever done it. You didn't ask me this question, so I'll ask the question to myself and answer.
Thank you.
The question is, why is mediation successful? Well, there's a few reasons why it's successful. One is parties sometimes want their day in court. You go through a lot of discovery and depositions, and you want to have your day in court. Well, a mediator, as I said, cannot make a decision, but a mediator is still a neutral. That you get to argue and stomp your feet and slam your fist on the table and just vent all you want. And you're arguing to a neutral, and sometimes that has an effect on, okay, I've made my arguments, and now I'm at least getting a reaction out of somebody who, you know, might be questioning some of my facts. That's one reason it works. The other is, parties usually walk into mediation with the mind of, yeah, it's time to resolve this. Sometimes it's early. I would say half my mediations are early mediation, which is a dispute is about to be filed or just got filed, but before the parties go into discovery, let's see if we can mediate this and resolve it. And sometimes it's after a significant stage, which normally is after discovery, but before parties file what's called motions for summary judgment and get prepared for trial. So we've got that. That's a good breaking point. A lot of money's been spent. We know all the facts. We've got the depositions. I like to tell this story to people in mediation. I had an arbitration years ago. It was a multi-million-dollar arbitration. 2 big companies. You'd know the name of the companies if I said them, but it's confidential, so I'm not. we had a lot of discovery, involved a lot of flights, airline flights. And then we had a hearing that lasted a week, including flying witnesses in. And after the hearing, the arbitrators have 30 days to issue their award. And this was a panel where there were 3 arbitrators. Around the 20th day, our client calls and he says, "Hey, I talked to the general counsel on the other side, been talking to him for the last week, and we settled the case." We went, "Okay, we better let the arbitrators know, like right now, because we don't need them issuing an award when you've already settled the case." Called them up, told them, said, "Don't do anything." They said, "Well, are you sure? Because we actually already drafted the award. We were getting ready to issue it." We went, "Nope, parties have settled it, just waiting for signatures. Don't release it." After the parties signed the settlement, the lawyers got together and said, "Aren't you curious what that arbitration order is? We paid for it, right? We paid for it. Out of curiosity, we'd really like to know what it is and whether we got a good settlement, bad settlement, whatever." The award was within $20,000 of what the parties settled for.
Oh, that's great.
Yeah, but for the $500,000 in attorney's fees each side paid to get there. And that's a story I like to tell is sometimes you're going to spend all this money and you're going to end up settling the case for what you could have settled it for in day one. And guess who won? The lawyers
Yeah.
and the arbitrators in that case. There was a three arbitration panel, so each party was paying for 1.5 arbitrator for a week. So anyway,
If
that's my
you
war story there.
No, that's a great story. If we go in for mediation and one of the parties is, "Okay, I'm here and I'm leaving because I don't want to do this."
Yep.
When you write that there's an impasse, does that go to the judge along with Mr. A was nasty and didn't even
Oh,
give this a chance?
okay.
Does the
That's a great question. Probably should have addressed this in the beginning. The hallmark of mediation is confidentiality.
Oh,
Absolutely nothing not referenced in, stated in the mediation, nothing about the process, nothing anybody says. Not the submissions of the parties, meaning mediation statements beforehand, can be used for any purpose whatsoever. And that is widely regarded and complied with. I have yet to see anybody ever try to use anything for mediation in court. Now, if somebody shows a document in mediation that is independently discoverable, that's fine. You can't exclude it just because it also is used in mediation. But the public policy behind this is that parties should be encouraged to speak openly and try to resolve their disputes. Now, by the way, this rule goes beyond mediation. If I as a litigant, if I were to send a letter to the other side and say, "Hey, before we go down this road, I offer to settle for X, or I offer to resolve this issue by replacing your septic tank and covering all the costs of the landscaping and everything." That's called an offer of settlement. There is a rule that says you cannot admit offers of settlement into evidence. So confidentiality is utmost. The parties also generally will sign a confidentiality agreement as part of the retention. And even the day of mediation, whoever walks in the room will be asked to sign a confidentiality agreement. And it also says that the parties can't call the mediator as a witness.
okay.
So here I am listening to people, sometimes very openly. You can't call me as a witness to say this is what somebody said in the mediation. Sorry, folks. I'm out. And again, I've yet to see in my career anyone try to get around that.
Okay. Could you get 40 hours of work a week if you wished?
Not now. to be honest. Um, some mediators reach that. The reason I can't now is because I'm still fairly new in this field. So, still getting my name out there. Got to participate in conferences. I'm speaking at an IP symposium in Florida next week, for example. Get involved in bar associations, show up to things where lawyers are at, and try to get the reputation of being a mediator. And how it works is you get one, that leads to two, that leads to four. Um, Arbitration, frankly, is a little easier to get into because we talked about how arbitration is a creature of contract. So if the contract says jams, somebody will file a claim with jams, and then jams will send out their forms about what you're looking for in the arbitrators, and then they'll send out their list, 10 people. Well, I'm on that list very often, in a very short time frame. I've been on many of those lists. And then I get an email, and all this is in the background. I don't even know this is happening. But I'll get an email from somebody in JAMS who says, you have been selected based on the ranks of the parties to arbitrate this case. How that works is you get 10 names, and each party ranks them 1 through 10. And you're allowed to strike some people as well. And then they compare the lists and they go, okay, this one had a 1, but this one had an 8. That's not going to work. This had 2. This one had a 3. That's pretty close. That's the arbitrator. I've been picked on several arbitrations over the last 2 months through that process. So a very well-seasoned 30 or 20, 30-year mediator, not year old, but as a mediator, they'll have calendars that I've looked up and they're full almost every single day. How they do it, I really don't know because I like to study the day before the mediation, really read the mediation statements. I like to talk to the lawyers ahead of time. I would say the most I could ever do doing that would be 30 hours a week, but I don't have any designs on doing that. I'm kind of enjoying my extra time. I'm an avid golfer and a member of a country club across the street, and I like getting out there 2, 3 times a week, if not more. But arbitration then gets a little more tricky because you'll have days where you have an hour conference, maybe an hour or two of studying documents, and then you get to a hearing. Sometimes hearing's 2 days, sometimes it's 3 days, sometimes it's 4 days. And it's kind of hard to fill in a consistent 40-hour-a-week schedule. My goal for where I am right now is to get to 20 hours. And I'd be happy with that. It would just, that to me is the sweet spot if I could get to 20 hours a week.
Okay. So you plan to do this for the foreseeable future?
Foreseeable future. Yeah.
I'm sorry.
Yeah, foreseeable future. Yeah.
If you can get that 20-hour sweet spot.
Yeah. Yeah. That's
Okay.
exactly it, and then I could take off several weeks, go travel or something anytime I want. I'm in 100% control of my schedule. Even as a litigant, as a partner where you technically control your schedule, the reality is the judge controls your schedule. Well, as an arbitrator, I am the judge. So I control the schedule, and it's usually disclosed to the parties, and the parties disclose their schedules to me. And we work that out when we do scheduling orders. But yeah, 20 hours, if it's under, if it bleeds over, fine. As far as the age of mediators and arbitrators are concerned, I'm still at the younger end of the spectrum, believe it or not, even though I'm kind of close to retirement age. But arbitrators, mediators tend to be very seasoned people. Legally was.
If you were doing one of the cases that you spoke about, two big businesses, would you rather have the case heard before a judge or a jury?
That's another, it depends.
Oh, there we go.
It really depends whether I think my case and my side of the case has jury appeal or not. Now there are other things that can control that. You know, arbitration again is a creature of contract. If you've got an arbitration clause, you're going to go to arbitration. You don't have an arbitration clause, then you're going to go to court. Some states allow you to waive juries in your contract. You can do that in Florida. You cannot do that in Georgia. I frankly never understood that Georgia rule because arbitration by its nature is a waiver of a jury. But for some reason that's okay. But anyway, that's the rule. And when you file a case, somebody has to file a jury demand. And if somebody files a jury demand, you're going to have a jury. If nobody files a jury demand, then you're not going to have a jury. I've had cases where the parties, after having already had a jury demand, later in time waive a jury.
Does a non-jury case go faster?
Yes. Yeah, for many reasons. You're not impaneling a jury, going through, it's called voir dire, when you question the jury and you select the jury. You got to go through all that, and then the objections have more precise need and more importance because you're going to the jury, who's the decider of fact. For those that don't know, judges decide questions of law. Juries decide questions of fact. And so as facts are coming in, objections become more important. There are sidebars, you probably see it on TV. Your Honor, may we approach? And you do that, so you have a discussion out of the hearing of the jury. Well, if the jury's not there, you just stay at your seats and you just argue all this stuff openly in front of the judge and the rest of the court. So it goes much, much quicker if you don't have a jury. Jury definitely slows things down.
Okay. Well, you've been wonderful. You explain everything. You explain the abbreviations. It's really been a pleasure speaking with you. Highlights. What are some of the highlights?
For a mediator, I mean, the highlight's getting a settlement. That's what we're hired to do, right? You get a settlement. I always, walk out of the room if it's live or hang up the Zoom and always have a smile on my face and I have a sense of accomplishment. Arbitration doesn't have the same satisfaction because you're generally ruling against somebody. Even if you're splitting the baby, it means you're not giving either party exactly what they wanted. So it doesn't have the same satisfaction. But I enjoy being in that neutral role where I get to do what I've counseled my clients for 30 years, which is try to put yourself in the shoes of the neutral. How would they sort through this dispute? Now I'm that guy. And I get to decide it, and I think I am doing the right thing for the parties.
Have you made any mistakes along the way that you said, gosh, I'm never doing that again?
Not in arbitration.
Okay.
Mediation, I only had a couple cases that didn't settle. So it's when you have a settled case, it's hard to say I should have done something. I've only had a couple cases that didn't settle. And when they don't settle, I do kind of review it in my mind and say, I wonder if I should have made this argument or taken this position.
Mm-hmm.
I'll give you an example to put some tangible facts on this. One of the tools mediator has is when the parties get bogged down in mediation and they're just not moving or they're not moving fast enough, or they're indicating they're at the end of their road. The mediator can issue what's called a mediator proposal, which is, I think the settlement value of this case is $500,000. You go to one room, you say, that's my mediator proposal. You talk about it and let me know if you accept or reject. I'm going to go to the other room. You go to the other room. This is my proposal, $500,000. Talk about it, accept or reject. The rules of the game are, if you say no, you will never know if the other side said yes or no.
Okay.
If you say yes and you don't have a settlement, you know the other side said no. And that's information that, yeah, we're flexible, they're not flexible, but maybe there's something better I could offer. If you say no, the other side says no. Well, I already said if you say no, you never know what the other side says. If you say yes, the other side says yes, you have a settlement. All right. I don't like to do mediator proposals. Different mediators are different in their belief on this because I'm not supposed to be judging the case. And even if I say this is the settlement value, not a reflection on the merits, not reflecting on who's going to win, who's going to lose, I'm considering your attorney's fees, I'm considering your distraction to your business, and I'm considering where you guys are in your settlement, which you're fictitious numbers at that point. I just feel like I shouldn't be telling them what I think the value of the case is because it's supposed to be in their control. I had a case where I told the parties I don't like to do that, and I didn't do that. It didn't settle, and I thought after the fact, you know what? I'm wondering if that's one of those cases I should have done. I still don't know if I did the mediation again, if I would, but you asked me, have I ever thought, boy, I wish I could do something different? That crossed my mind that maybe that was the case to do it.
Fair enough. I understand that. But and as you're saying, especially with the mediator uh, offer, so if a person is not an attorney and they become a mediator, they're not they may not have a full understanding of what the court costs would be as an alternative that you can say to the two clients, you realize that this is going to cost you X amount of money to settle this in court instead.
Yeah, yeah. And that's why it's a big part of the mediator's arsenal. Like I said, I'll flat out ask the lawyer in front of the client, have you provided a budget? And is it a fixed number or is it a range? Because it always should be a range. Because I don't know how long the depositions are going to be. I don't know how many documents are going to be produced. I don't know if additional witnesses are going to be found. I just don't know. But anyway,
Is this a growing profession, mediation and arbitration?
absolutely.
Nope. Did anybody in the fraternity help you get into this business?
No, to
Okay.
be honest, not because of, just simply they're just not in the same field.
All right. No, I
So,
understand. Do you have anything else that you'd like to offer to an undergraduate who might be thinking of going into this industry?
well, I still recommend going to law school. I think it helps. I don't know the numbers, but my belief is that the neutrals who are not lawyers are not getting the same level of business as those who are. That's number one. Um, Before you go to law school, give this consideration. As we talked about today, was a computer programmer for 7 years. Um, it gave me a different perspective going into law school. I'm not saying wait 7 years to go to law school, not at all. But I would say before you go to law school, um, or I should say before you go to law school, immediately after undergrad, just give some thought to whether you really are ready for law school or whether even a year off might be a good move because I did see somewhat of a difference in the students who are right out of undergrad versus those who were out for at least a few years. I'm not saying the ones out for a few years perform better. That is not true at all. That the people at the top of my class were all people who were traditional straight through law students. I just say just give it some thought because I do know a couple of people who once they were into it, they were like, this just isn't me. Or they got out and within a year or two of being a lawyer, they were already out of the profession. So just give that some thought. And then get experience once you're going through law school. Take advantage of a summer clerkship if you can. What I mean is a summer intern, meaning working for a law firm. Usually courts don't hire law students. And then, maybe that leads to a job, maybe you end up in a clerkship. But if you do go for what is a lot of money these days, and it is a lot of money that they're paying first year lawyers, don't be afraid to constantly knock on the partner's door. It should be open anyway. And say, I want work, I want work, I want work. You got a deposition. Can I go to your deposition? Oh, you got a court hearing. Can I go and watch? Even if you don't get to bill for it, even if the firm is going to give you a bonus for billing as much as you could bill, sacrifice some of those hours to actually see how court works. Now, I'm talking from a litigation perspective, from a corporate perspective, real estate, corporate. When there's a closing, can I go to the closing? Can I see what actually happens? Because there's different areas of the law. It's not all litigation. You don't go just for the dollars and just for the hours at the sacrifice of experience that will carry you much further in the future.
All right. This has really been a pleasure. I've really enjoyed speaking with you. I've learned a lot, and I appreciate you explaining everything, explaining the acronyms, and I wish you luck getting that 20-hour sweet spot. And I really appreciate you coming on with me.
Stan, it was a pleasure.
Thank you very much. Take
All right.
care.
All right.
Bye-bye.